Everything I share today is for educational purposes only. This is not legal advice, and I am not your attorney. If you have received a grand jury subpoena or believe you are the target of a grand jury investigation, contact a licensed criminal defense attorney immediately. You wake up one morning and federal agents are at your door. They hand you a subpoena. You are required to appear before a grand jury. You do not know what they are investigating. You do not know if you are a witness or a target. You do not know what evidence they already have. And you are not allowed to bring your attorney into the room with you. Most Americans have never heard of a grand jury until the moment one touches their life. And by that point, it is almost always too late to understand what is actually happening. Today, I am going to pull back the curtain on one of the most secretive and powerful institutions in the American criminal justice system. What a grand jury actually is. What happens inside that room, what rights you have, and what it means for you if one is investigating something connected to your life. The issue. Before the government can formally charge someone with a serious federal crime, it must first convince a grand jury that enough evidence exists to justify bringing that charge. This is called finding probable cause. The grand jury acts as a check on prosecutorial power. A group of ordinary citizens who are supposed to stand between the government and the accused and ask, is there actually enough here to put this person on trial? That is the theory. The reality of how grand juries actually function in America is far more complicated and far more powerful than most people realize. The law. The Fifth Amendment to the United States Constitution requires that no person shall be held to answer for a capital or otherwise infamous federal crime unless on a presentment or indictment of a grand jury. This means that for serious federal crimes, the government cannot simply file charges. It must first go through the grand jury process. This requirement applies to federal cases. States are not required by the Constitution to use grand juries, and many have moved away from them for most cases, using instead a process called a preliminary hearing, where a judge, rather than a citizen panel, reviews probable cause. A federal grand jury consists of between 16 and 23 citizens. They serve for an extended period, sometimes months or even years, hearing evidence on multiple cases. To return an indictment, at least 12 grand jurors must agree that probable cause exists. Here is what makes the grand jury process so uniquely powerful and so unlike anything else in the legal system. Grand jury proceedings are completely secret. The public cannot attend. The media cannot attend. The target of the investigation usually does not even know an investigation is happening until an indictment is returned or a subpoena arrives. The rules of evidence that apply at trial do not apply in the grand jury room. Hearsay is allowed. Evidence that would be thrown out at trial can be presented to a grand jury. The prosecutor controls what evidence the grand jury sees. The defense presents nothing. Because there is no defense in a grand jury proceeding, witnesses called before the grand jury have no right to have their attorney present in the room during questioning. An attorney can wait outside, and the witness can step out to consult with them between questions. But inside that room, it is the witness alone facing the prosecutor and the grand jury. The standard of proof is probable cause, far lower than the beyond a reasonable doubt standard required for conviction at trial. Probable cause simply means a reasonable belief that a crime was committed and that this person committed it. This combination, secret proceedings, relaxed evidence rules, no defense presence, low standard of proof, and complete prosecutorial control, is why the famous saying exists that a skilled prosecutor could get a grand jury to indict a ham sandwich. That phrase was coined by a New York judge and it reflects a genuine critique of how one-sided the grand jury process actually is in practice. Real-world application. Michael is a mid-level manager at a financial services company. He has no idea that his company is under federal investigation for fraud. One afternoon, he receives a grand jury subpoena requiring him to appear and testify and to bring certain company documents with him. Michael is not told whether he is a witness, a subject, or a target. These are three legally distinct categories. A witness is someone who has information but is not suspected of wrongdoing. A subject is someone whose conduct is within the scope of the investigation, potentially suspected, but not yet the focus. A target is someone the grand jury and prosecutor believe committed a crime, and against whom an indictment is likely. Michael goes to his attorney. His attorney immediately writes to the prosecutor asking for clarification of Michael's status. The answer to that question fundamentally changes the legal strategy. A witness may be able to testify safely with proper preparation. A target should almost certainly invoke the Fifth Amendment right against self-incrimination and refuse to testify entirely. Michael learns he is a subject, somewhere in the middle. His attorney prepares him carefully. They go through every possible question. They identify the areas where Michael must invoke his Fifth Amendment right. They negotiate with the prosecutor about the scope of the document request. 6 months later, no indictment. The investigation moves in a different direction. Michael's careful legal preparation almost certainly prevented a very different outcome. Common mistakes. The first mistake is appearing before a grand jury without first consulting a criminal defense attorney. This is the most dangerous mistake a person can make, even if you are completely innocent, even if you have nothing to hide. The grand jury room is not a place to tell your story and clear your name. It is a place where your words, taken out of context, misremembered, or slightly inconsistent, can be used to charge you with perjury or obstruction, even if the underlying crime is never charged. The second mistake is assuming that because you are innocent, you have nothing to worry about. Innocent people make inconsistent statements under the stress of questioning. Innocent people misremember dates and details. A skilled prosecutor can use those inconsistencies to build a perjury case even when the original investigation goes nowhere. Innocence is not protection from grand jury danger. The third mistake is not understanding the difference between witness, subject, and target. Your legal rights and your legal strategy depend entirely on which category you fall into. Never appear before a grand jury without knowing your status. And even then, understand that your status can change without notice during the proceedings. The fourth mistake is producing documents without attorney review. Grand jury subpoenas for documents are powerful legal tools, but they have limits. Certain documents may be protected by attorney-client privilege. Certain document requests may be overly broad and subject to legal challenge. Never hand over documents in response to a grand jury subpoena without having an attorney review what is being requested and what must, or must not, be produced. The fifth mistake is talking about the grand jury investigation with anyone other than your attorney. Grand jury secrecy rules bind the jurors and prosecutors. They do not always bind witnesses. But talking about a grand jury investigation, to co-workers, to family members, to anyone, can create additional legal exposure and in some circumstances can be characterized as obstruction of justice. Your action steps on. If you receive a grand jury subpoena of any kind, your very first call must be to a criminal defense attorney before you do anything else, before you tell your employer, before you tell your family, before you respond in any way. Call an attorney. 2. Ask your attorney to immediately contact the prosecutor's office to determine your status, witness, subject, or target. That answer drives every decision that follows. 3. Do not produce any documents in response to a grand jury subpoena until your attorney has reviewed every document being requested, identified any privilege issues, and determined whether any portion of the subpoena can or should be challenged. 4. If your attorney advises you to invoke your Fifth Amendment right against self-incrimination, do exactly that. Invoking the Fifth Amendment in a grand jury proceeding cannot be used against you in a subsequent criminal trial. It is a constitutional right that exists precisely for situations like this. 5. After any grand jury appearance, debrief completely and immediately with your attorney. Go through every question asked and every answer given while memory is fresh. Your attorney needs that information to assess your exposure and prepare for whatever comes next. The grand jury is one of the oldest institutions in American law, designed as a shield between citizens and government overreach. In practice, it has become one of the most powerful tools in the prosecutor's arsenal. Understanding how it works before it touches your life is not paranoia. It is preparation. Share this with someone who needs to understand how the system really operates beneath the surface, and for any real legal situation, always speak with a licensed criminal defense attorney immediately.